What were the issues framed by the trial court?
At internal page 9 of the order. Issue number 1 is the suit material in the present form. 2 is have the plaintiffs have valid cause of action for the suit. Is the suit hit by principle of waiver, accusation, estoppel, and res judicata? Is the suit bad for non-joinder and misjoinder of parties? Is the suit undervalued? Whether the plaintiff have got any right, title, and interest over the suit property? Whether the plaintiff are the owner in possession of the suit property with all rights and interest? Whether Muhammad Sheikh or Dulali Bibi sold transferred the suit property to defendants if there is any paper with the defendants regarding the suit property in their favor is forged and same is not binding upon the plaintiffs. Whether the possession of the defendants of the suit property is illegal and liable for ejectment. Whether the oral gift by omission BB of her half undivided shares and interest in plot number 698 to her sister commission BB is valid and legal under the Muhammad law. Are the plaintiffs entitled to get reliefs as claimed for? To what any other reliefs or reliefs the plaintiffs are entitled? The Learned Trial Court has dealt the issue number 6 and 7 first. Whether the plaintiffs have got any right, title, and interest over the suit property, and whether the plaintiffs are the owner in possession of the property.
What is the finding?
Finding, Lordship, and allow me to read the finding, Lordship. As per the plaintiff, it is the case of the plaintiff that the land of plot number 703 are 1 Kattha, 16 Dhur of Mauja, Magdampur. Their maternal grandfather, namely Muhammad S.K., transferred the land of plot number 703 through registered deed of Hiba Bil Awaz dated 13-10-67. As a matter of fact, they got the land of 1 Biga, 11 Kattha through registered deed of 3207-69, but they transferred 1 Biga, 15 Kattha, 8 Dhur, so they got mutated only remaining area of 5 Kattha, 12 Dhur in mutation case number 411 of 8788 in their names as Jamawandi number 293 of 23, holding number 8 of 95. The plot number 69 of the suit lands are 4 Katthas, 5 Dhurs pertaining to the Jamawandi number 293 of 53 of the aforesaid Mauja Magdampur, stands recording the last survey in the name of one Dulali Bibi, wife of Muhammad S.K., and was possessed the same and paid the rent for the same so long she was alive. The recorded tenant Dulali Bibi died about 30 years back, leaving behind her 2 daughters named Commission Bibi or Mission Bibi, who inherited the entire land of plot number 698.
Case number 345 of 2016. Nobody appears on behalf of the appellant. Also for the respondent is present. The records of the case reveal that the case was repeatedly taken up by this court and was adjourned at the request of the appellant upon payment of fine, payment of cost. The case was taken up in the first half and a prayer for adjournment was made and the matter was to be taken up in the second half. When the case is called out in the second half, nobody is appearing. Accordingly, this appeal is dismissed for purpose.
Item 16, second appeal 499 of 2016.
कब के लिए चाहिए मैडम? आपके हिसाब से टाइम देगा ना। छुट्टी के बाद का आपका एक केस रखे ना, कौन तारीख को रखें इनका एक केस?
क्योंकि वो एक्चुअली सबका
10 जून को ही रहेगा ये वाला। कौन सा वाला ऑर्डर?
एक्चुअली तब तक is going on, so
आप यू कैंट हैव इट बोथ वेज ना। हाँ बताइए कौन सा, मतलब कौन सा केस में 10 जून गया था? सीरियल नंबर
ये सीरियल में 11 सेकंड थी 302
सीरियल नंबर 11 में किसने ऑर्डर किया है? विनीत जी। सेम ऑर्डर इसमें कर देंगे 11, ठीक है। इसे नहीं
Item 17, second appeal 254 of 2019.
Wait, please, Your Lordship, this is the second appeal referred against the concurrent finding of the trial court and the appellate court. The appellant herein was the plaintiff who had filed the suit for declaration of right, title, and possession. Trial court judgment is at page 22.
You filed the suit only for declaration of title
Yes, Your Lordship.
or for possession also?
For title, I was in possession.
You sought a declaration that it is the self-owned property.
Self-acquired property of the plaintiff based on hukumnama.
Self-acquired property.
Yes, Your Lordship. Yes. Let's say it is the case of the plaintiff that this
Who were the defendants? Family members?
yes, Your Lordship. Family members were the defendants.
Was there any partition earlier?
There was partition between both the parties, but not with respect to this land.
This was not.
This was not partition.
What is the finding?
Finding is that this both the parties, the plaintiff and the defendant, both the parties had submitted one hukumnama, two different hukumnamas, and it was held that hukumnama submitted by this plaintiff was a false one, and it was not declared that their hukumnama was correct. It was only declared that this plaintiff has not been able to prove this case, for the reason that there was interpolation in registered proof. Earlier, the name of ancestor of this plaintiff was entered in registered proof, which was subsequently removed, and name of this plaintiff was entered. Based on that evidence, the suit was dismissed. Now, what had happened, Your Lordship? The hukumnama, which was issued to this plaintiff, in that hukumnama it was written that अदला बदली करने के लिए हुक्मनामा. Now, case of the defendants is that disputed land was settled in the name of Videsi Lohar, the ancestor of
We
this
are not
plaintiff.
on this.
Yes, Your Lordship.
There are concurrent findings.
Yes.
What is the question of?
Yes, Your Lordship. I am coming to that, Your Lordship. Now, what has happened, Your Lordship? Both the courts have decided the age of this plaintiff without any documentary evidence, only on the basis of oral evidence, and no issue with respect to that has been framed. Only on the statement of 2 to 3 witnesses, the finding has come that this plaintiff was minor when this hukumnama was alleged to be issued in the name of this plaintiff. Whereas this plaintiff has stated that he was major at the time when the hukumnama was issued.
What is the date of हुक्मनामा? हुक्मनामा तो 1950 के पहले का ही होगा ना?
हाँ, 1941 का है, 1941 का. And on the date of judgment, on the date of filing of this appeal, the plaintiff, the appellant was aged about 87 years.
in 2019, you let's say.
When was the suit filed?
Suit was filed in the year 2006.
2000.
2000, 144 of 2000.
Did you file the original hukumnama?
Yes, your let's say.
Exhibit number?
Exhibit number 7 with objection. Exhibit 7. Page 26 of the trial court. Paragraph 6.
You read internal page 9 of the trial court judgment.
Paragraph 11, you read.
Para in the middle. The plaintiff PW6 himself stated in para 12 on 19/4/2003 that he was married 22 years ago at the age of 22 years. And so from the calculation, he was 59 years old on 19/4/2003. And so the plaintiff was minor at the time of execution of Exhibit 7. क्या बोलना है आपको इसके? The age is determined from your evidences also and
But
supported.
But on affidavit, you let's say.
How does that make a difference? You have given oral evidence about your age. इतना calculation नहीं
He
कर
was
पाएंगे.
married 22 years ago at the age of 22 years.
इस calculation में कोई गड़बड़ नहीं.
And so from calculation, he was 59 years old on 19/4/2003.
अब plaintiff
Yes, your Lordship.
बात करते हैं. Correct?
Let's go.
वैसे भी reappreciation of evidence second appeal में नहीं होता. There are concurrent finding that you were minor at that point of time. Then under such circumstances, आप बोले कि oral evidence आप ही के evidence को तो use किया.
So let's see, at the time of examination and cross-examination, this
इसीलिए ना क्रॉस एग्जामिन किया था आपको.
disturb हो
आपको
जाता
समझ
है.
में
Disturb हो जाते हैं, बता नहीं पाते हैं evidence.
जो अगर विटनेस डिस्टर्ब हो जाए ऐसा कोई सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं बनता है.
But there is no other evidence, your Lordship, other than
Need
this.
not be.
And there is
Your
there-
statement is the best evidence.
and there is report of the Anchal Amin, your Lordship, that I was in position and
उससे क्या? एडवर्स पोजीशन क्लेम किए हैं.
no.
बात करते हैं. देखिए हो गया.
Your Lordship, हुकुमनामा अदला बदली का था, तो इसलिए वो हो सकता है कि
नहीं हो सकता. एक तो सादा हुक्मनामा अपने आप में बहुत डाउटफुल डॉक्यूमेंट है.
both the parties, your Lordship, they have submitted सादा हुकुमनामा.
उनका 1933 का हुक्मनामा.
Yes, your Lordship.
And they have proved it also. देखिए essay number 254 of 2019 heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the hukumnama which was exhibited by the appellant, who was the plaintiff, has been disbelieved on the ground that plaintiff was a minor at the time of the execution of Hukumnama Exhibit 7, which was dated
1941 you did say.
which was of the year 1931. The Learned Counsel submits that no documentary evidence was produced in connection with the age of the plaintiff, and the defendant was also claiming on the basis of Hukumnama, which was of the year 1933. The Learned Counsel has submitted that on account of such finding, the impugned judgments are perverse and call for indifference by framing a substantial question of law. Upon perusal of the records of this case, this court finds that the specific case of the plaintiff was that he acquired the property through a hukumnama given by the then manager Ward Estate Ganwan in the year 1941, and since then he has remained in peaceful possession of the suit property and has been cultivating crop. Plaintiff and defendants are Gotiyas, and they were joint in title from fourth generation upward from the plaintiff. It was also the case of the plaintiff that Vidishi Lohar was the Khatyani Rayar. He had two sons, namely Chandu Lohar and Tilak Lohar, and both of them got separated in mess business after death of Vidishi Lohar in the year 1925. Chandu Lohar died in 1935, leaving behind two sons, Sitaram Lohar and Baijnath Lohar, who died issueless in 1950, and Sitaram Lohar died in 1942, leaving behind the plaintiff. The plaintiff, in the lifetime of his father, had acquired the suit land. Tilak Lohar was also living separately from his full brother Chandu Lohar, who had two wives. And from one wife he had three sons, namely Ramkishore Lohar, Palgovind Lohar, Harijan Lohar, and only one son, namely Divakar Lohar, from another wife. It was a case of the plaintiff that after settlement of suit land, he paid rent regularly to the landlord and thereafter to the government of Bihar after vesting of estate, and was getting rent receipt in Zone A. The cause of action arose on 25/2/2000 when the defendant tried to dispossess the plaintiff from the suit land. However, in the year 1978, the circle officer had reported possession of the plaintiff and the defendant in his report. It was also asserted that in Jamabandi cancellation case number 62 of 1995-96, the suit land was said to be in exclusive possession of the plaintiff. And it was further case of the plaintiff that the defendant later on filed an appeal before the judicial collector where the defendant allegedly managed a compromise between the two parties while disposing of the bill. And the additional collector directed the lower revenue court to deal with the matter in accordance with law. And the defendant managed an order for changing the name of the plaintiff by the name of his great grandfather, Vidisi Lohar. The suit was filed for declaration that it was the self-owned property of the plaintiff, and he had exclusive title over the same. The defendants filed the written statement stating that the suit was barred by limitation, adverse possession, waiver, estoppel, and acquiescence, and that the suit was undervalued. The specific case of the defendant was that the plaintiff had incorrectly and falsely stated his age as 80 years in the affidavit filed in the plaint, and that he was not more than 60 years, and that the suit was barred by Section 34 of Specific Relief Act. The defendant denied that the suit land was the self-acquired property of the plaintiff in 1941. Rather, the ancestral land of both the parties was recorded in the name of Vidisi Lohar in Khatian, who did not die in 1925, rather died in 1940, and his sons got separated much thereafter. Chandu Lohar died in 1944, Tilak Lohar in 1945, Sitaram Lohar in 1955, and Baznath Lohar in 1950. And that the suit land was acquired by Vidisi Lohar on 11 to 1933 from the landlord manager Ganwan Ward and Estate through Hukumnama, followed by delivery of possession and acceptance of rent. And Vidisi Lohar came in possession of the property. It was a further case of the defendants that Vidisi Lohar and his two sons came in joint possession over the suit land as well as other ancestral land, each having equal share. And after the death of Chandu Lohar, Tilak Lohar, their sons got separated and came in possession of the suit property. The name of Vidisi Lohar was running in Register 2 of the Circle Office, and defendants were in possession of the property, which came in their share. It was alleged that the plaintiff got the name of Vidisi Lohar penned through Register 2, and when arose a dispute under Section 145 CRPC, it ended in a compromise on 10/6/1996. And in that proceeding, it was decided that both the parties would get equal share in the suit land. The disputes later on arose before the Revenue Authority, and the matter came up to the Court of Additional Collector Girirdi in Miscellaneous Appeal number 125 of 95/96, which was disposed of on compromise, which was duly signed by both the parties. The plaintiff had again filed a petition, being miscellaneous case number 19 of 97/98, alleging that the plaintiff was not being allowed to have half share of the suit property, and to restore miscellaneous appeal number 125 of 95/96, which was rejected by the Additional Collector Girirdi by order dated 16/4/1998. The defendant was coming in possession over half area of the suit land peacefully, continuously, and openly for more than 75 years to the knowledge of the plaintiff, and it was stated by the defendant that they have also perfected their title by way of adverse possession. The appellate court, the trial court framed the following issues, and ultimately the issues were decided against the plaintiff, The learned trial court considered the evidence of the plaintiff himself, and on the basis along with other evidences, on the basis of which a finding was recorded that the plaintiff was minor at the time of execution of Exhibit 7 in the year 1941. The learned trial court rather held that the admission of the plaintiff witness and the plaintiff himself proved that when the suit was filed, the plaintiff was 60 years old, which in turn suggested that plaintiff was not even born in 1941 when the said Hukumnama, which was said to have been issued in favor of the plaintiff, was allegedly issued in the year 1941. Ultimately, the suit was dismissed by the learned trial court. The learned trial court also recorded that the Sada Hukumnama Exhibit 7 was without any evidence of return being filed by the ex-landlord, coupled with doubtful entry in Jamabandi Register 2, which created a serious doubt over the veracity of the Hukumnama and the title through that. The learned appellate court also considered the materials on record and gave concurrent findings. The finding recorded by the learned appellate court in paragraph 11 is quoted as such. This court finds that there are concurrent findings recorded by both the courts, that disbelieving the claim of plaintiff on the basis of Hukumnama of the year 1941, which also includes the appreciation of evidence of the plaintiff and his witnesses. This court finds that no substantial question of law is involved in the present case. According to the second appeal, is dismissed.
Automatic second appeal 258 of 2019.
This is the defendant's second appeal against the judgment of affirmance. When a suit was filed by the plaintiff, that is title suit number 56 of 2004, for a specific performance of contract, agreement dated 28/5/1998, Exhibit 1, for sale of 47 decimal of land of plot number 1248 under Khata number 85. For a
You
sum
are
of-
the defendant.
Yes, defendant.
Just-
There are two sets of defendants.
Defendant. You are the defendant, subsequent purchaser.
The vendor and another set is they have included the purchaser also.
Okay.
Similar out of 42 decimal, which was the subject matter, 47 decimal, subject matter of agreement Exhibit 1, dated 28/5/1998. 28 decimal has been sold to the defendant number 4.
28/5/20.
28.5.
28/5 Exhibit 1 का क्या है? What is the date of the agreement?
Agreement is 28/5/1998.
28/5/98. Exhibit 1.
Exhibit 1. And so far, Milord, the sale deed is concerned, the defendant number 1 sold 28.7 decimal to the defendant number 4 on 30th January 2006. Now, the case of the plaintiff is that, as per the agreement, he paid rupees 20,000 by way of advance out of rupees 1,06,000. So 86,000 was to be paid. It is also alleged.
86,000 to be paid.
Yes. 86,000. Now, my lord, out of which he further split it that for the expenses for at the time of permission, he again paid my lord rupees 5,000. So it was 81. Legal notice was sent my lord on 29/5/2002. 29/5/2002. And permission was allegedly granted on 6/7/2004. And the suit was filed in 2004.
29/5/2002 is the legal notice.
Legal notice. Suit was filed in the year 2004.
Any date?
Yes, some date I am just. The decree itself. Sorry, I have the certified copy with me. 31/5/2004. 31/5/2004. Claim was amended. The defendant number 4 was imputed as a party. He also filed a written statement. Now, if your lordship may kindly see for a moment.
So what is the point you want
The
to say?
point, I'm just advancing my point. But before that, the certified copy of the agreement, which is Exhibit 4, Exhibit 1, it says, my lord, that the vendor will execute and register the proper sale deed in favor of the purchaser within a period of 6 months. The period was 6 months. And if the purchaser fails to pay the balance amount to the vendor, then the amount will be forfeited. And otherwise, if the vendor fails to execute the deed, then within the stipulated period after receiving the balance amount from the purchaser will be liberty to get the sale deed registered to court. These are the two conditions. Now, your lordship may kindly see, in the entire plaint, there is no prayer for cancellation of sale deed. Now, if there was no prayer for cancellation of sale deed, so my lord, out of 42 decimal, if 28.7 decimal admittedly as per the pleading and the plaint, if it was sold, then how the learned courts, without taking into consideration this aspect of the matter, could have decreed for a specific performance of contract in respect of entire 47 decimal of land. This is first point. Second point, what is the specific performance of contract? Your section 16(1)(c) is the mandatory provision. The plaintiff has to show the readiness and willingness by performing his part of the contract. That will not be appreciated. Now, your lordship may kindly come to para 6 of the trial court judgment, which are the issues. Issues not framed. Limitation, issue number 3, page 14 is the reply. The specific relief act readiness willingness, para 6, issue number 6. If your lordship may kindly come to para 6 of the trial court judgment. और
इसमें कौन-कौन सा issue important है?
Lord,
कौन-कौन सा issue important?
issue number 3, limitation. Issue number 6, as to whether the plaintiff ready,
That's right. And issue
readiness
number?
and willingness.
Issue number?
6.
हाँ ठीक है देख लीजिए.
Then your lordship may kindly see, my lord,
These two issues are important.
important, and then it is consequential issue number 8. 8 is the execution of the agreement.
That's right. Basically 3 and 6.
3 and 6. So your lordship may kindly.
There was no issue framed that the property was already sold.
No, that is my point. The pleading is there. Even the defendant number 4 was added as a party, implicated as a party. His written statement is there. Even the plaint shows. If you lordship may kindly see the trial court judgment, only one line.
Defendant number 4, his sale deed was preceded by any agreement.
Need to direct sale. Direct sale after when he failed to execute his part of the performance. If you lordship may kindly see the appellate court judgment, place of the plaintiff, only one sentence. It is not that the new strange thing. Lordship may kindly see
This law is settled. There is no need to challenge the subsequent settlement.
No, my lord, there is, my lord, so far that part is concerned.
That initially that law was there, subsequently it went to a larger bench by the Honorable Supreme Court, and that law has changed.
The lordship may kindly see here it has been deeded by the plaintiff. If your lordship kindly see page 3 of the appellate court judgment, last but third line. The plaintiff has purchased non-judicial stamp paper such and did not turn up to execute the sale deed. The defendant has sold the suit property to Akshay Kumar Singh, son of such and such, defendant number 2. Sorry, I'm 4 बोल रहे हैं बार-बार. That is 2. Right, sale deed number 701 dated 30th January 2006. The plaintiff was in possession of a suit land which was within the knowledge of Akshay Kumar Singh, had full knowledge about the earlier. The sale deed dated such and such dispute. Despite the same, he purchased the suit land. The cause of action arose such and such. Now, your lordship directly come to para 13 and 14 of the trial court judgment.
Hmm. 2006 में ना परचेज किए हैं
Yes.
और आपका 98 का है.
98 का एग्रीमेंट था, 6 महीना ब्रेक था.
हाँ, तो उसके बाद क्या किया?
उसके बाद हम बेच दिए. जब वो नहीं दिए पैसा 81,000 as per the owns case of the plaintiff. Lordship just kindly come to finding 13 and
आपका
14.
डिफेंडेंट है ना?
हम डिफेंडेंट हैं,
हाँ,
हम ही लोग वेंडर हैं.
हाँ.
और जो पैरा 13 एंड 14 देखा जाए किस तरीके से डील किए हैं ट्रायल. पेज नंबर 13 ट्रायल कोर्ट का हिंदी वाला है. पेज 13 का पैरा 13 पेज 13 पैरा नहीं, पेज पैरा वाइज नहीं है, पेज 13. Lordship just come to mirror towards middle exhibit 1 others 1 towards middle 29/5/2 के वादी द्वारा वकालतन नोटिस देकर मृतक परिवादी धनंजय हजरा को 1998 तथाकथित एकरारनामा का अनुपालन करने को कहा गया, जिसका अनुपालन मृतक प्रतिवादी नहीं किया गया. इस बात में मृतक प्रतिवादी धनंजय हजरा द्वारा अपना लिखित बयान 23/7/2004 को अतिरिक्त लिखित बयान 24/11/5 को दाखिल किया गया. यह जानते हुए कि विवादित जमीन के संबंध में बात न्यायालय में लंबित है, बात पत्र की अनुसूची में वर्णित विवादित जमीन में से 28.07 डिसमिल 30/2006 को प्रतिवादी संख्या 1 को बिक्री कर दिया. वादी में प्रतिवादी 2 जमीन पर अपने अपने कब्जे की बात कहा गया, लेकिन वादी के साथियों से प्रतिवादीगण द्वारा वादी के कब्जे संबंध में प्रतिवादीगण के दौरान कुछ भी नहीं पूछा गया, जिससे प्रतीत होता है कब्जा वादी का प्रतीत होता है. उपरोक्त तथ्यों एवं अभिलेख पर उपलब्ध सामग्री को विवेचना से यह स्पष्ट हो जाता है कि वादी एवं प्रतिवादी धनंजय हजरा के बीच बातपत्र की अनुसूची में वर्णित विवादित जमीन का विक्रय हेतु पदस्थान का निष्पादन किया गया. इस दिन मृतक प्रतिवादी धनंजय हजरा द्वारा 20,000 रुपया अग्रिम और 5,000 रुपया बाद में लिया गया. अभिलेख पर प्रतिवादी द्वारा ऐसा कोई दस्तावेजी साक्ष्य प्रस्तुत नहीं किया गया जिससे स्पष्ट हो कि वह अपने भाग का संविदा अनुपालन. That is, the onus has been shifted to the defendant. It is for the plaintiff to show and establish 16(1)(c) readiness and willingness. Now it has been shifted to the defendant. This is one part. Then your lordship may kindly see इस प्रकार वादी का प्रतिफल राशि देने
ये तो गलत. It's an error of it's a typographical error.
कंटिन्यूटी में पढ़ी.
हाँ, कंटिन्यूटी में
पढ़
पढ़िए.
देते हैं. 10 प्रतिवादी द्वारा
नहीं, इसको उपरोक्त तथ्यों से पढ़िए.
उसके पहले हम पढ़ रहे थे, उसके ठीक पहले
हाँ,
जो पेज नंबर 13 का लास्ट 2 लाइन.
हाँ. नहीं, उसको ऊपर से पढ़िए ना. उपरोक्त
अच्छा,
पूरा
उपरोक्त
पैराग्राफ.
तथ्यों एवं अभिलेख पर उपलब्ध सामग्री के विवेचना से यह स्पष्ट हो जाता है कि वादी एवं प्रतिवादी धनंजय हजरा के बीच बातपत्र की अनुसूची में वर्णित विवादित जमीन की बिक्री हेतु पदस्थान 1 का निष्पादन किया गया. जिस दिन मृतक प्रतिवादी धनंजय हजरा द्वारा वादी से 20,000 रुपया अग्रिम के रूप में लिया गया तथा बाद में 5,000 रुपया लिया गया तथा अभिलेख पर प्रतिवादी द्वारा ऐसा कोई दस्तावेजी साक्ष्य प्रस्तुत नहीं किया गया जिससे यह स्पष्ट हो कि वह अपने भाग के संविदा का विनिर्दिष्ट अनुपालन हेतु तैयार थे. So it is for the plaintiff.
आगे पढ़िए.
आगे पढ़िए.
वो typographical.
इस प्रकार वादी एवं प्रतिफल राशि देने वादी शेष प्रतिफल राशि देने एवं अपने पक्ष में बिक्री पट्टा निष्पादित कराने का तैयार है, जबकि प्रतिवादी ऐसा करने को तैयार नहीं है। ऐसे प्रतिवादी द्वारा ऐसा कोई भी कागजात प्रस्तुत नहीं किया गया जिससे स्पष्ट हो कि एग्जिबिट 1 का अनुपालन करने हेतु तैयार थे। दिस इज रिपीटेशन,
आगे
इट
पढ़िए।
कैन नॉट बी एन एरर।
आगे पढ़िए। साथ ही
वादी प्रतिवादी के विरुद्ध 28/5/98 के संविदा के विनिर्दिष्ट अनुपालन के डिग्री पाने के भी अधिकारी हैं। वादी वाद पत्र में मांगे गए अनुतोष को भी पाने का अधिकारी हैं। मृतक धनंजय द्वारा वादी को विवादित जमीन का कब्जा दे दिया गया है, जिस पर वादी कब्जे में है, अतः वाद बिंदु शासन। दैट इज आल्सो ऑन प्रिजम।
तो वादी का रेडीनेस विलिंगनेस का फाइंडिंग ऊपर होगा ना। देखिए, दो रेडीनेस विलिंगनेस, एक है प्लेंटिफ का, और अगर प्लेंटिफ अपना प्रूव कर लिया
प्रूव
तो
करें
डिफेंडेंट का।
तब उनका होना सकता है।
हाँ।
पहले तो रेडीनेस
Is there any finding that the
That is
plaintiff
the
was ready? ये जरा थोड़ा ऊपर से पढ़िए। उभय पक्षों के विद्वान अधिवक्ता को यहाँ से पढ़िए।
वहाँ से पढ़िए।
उभय पक्ष
जी। ये इशू नंबर 6, 7, 8, 9 चारों इशू।
पेज नंबर 12
पेज
का।
नंबर 12 का ही पढ़ रहे हैं। पेज नंबर 7 से शुरू होता है। पहले हम दिखा देना चाहेंगे कि सब इशू को एक
हाँ
साथ।
ठीक है, कोई भी उसमें दिक्कत नहीं। अब यहाँ से पढ़िए ना, उभय पक्षों के विद्वान।
और पेज नंबर
12 के मिडिल में है।
उभय पक्ष के विद्वान अधिवक्ताओं को सुना। अभिलेख पर उपलब्ध उभय पक्षों के अभिकथन वचनों एवं उभय पक्षों की ओर से प्रस्तुत मौखिक व दस्तावेजी साक्ष्य के विवेचना किया गया, जिससे यह स्पष्ट होता है कि बात पत्र की अनुसूची में वर्णित विवादित संपत्ति सचनसा 47 डिसमिल जमीन को बिक्री हेतु एक एकरारनामा वादी तथा मृतक प्रतिवादी धनंजय हजरा के बीच 1998 में निष्पादित हुआ था। पदस्य जमीन धनंजय हजरा की पैतृक संपत्ति है। एकरारनामा पर साक्षी विदेशी को मृतक प्रतिवादी धनंजय हजरा के पुत्र पाली हजरा के द्वारा 28/5/98 को अपना हस्ताक्षर किया गया था, जिन्हें दोनों साक्षियों द्वारा स्वीकार किया। साथ ही उभय पक्षों द्वारा एकरारनामा के निष्पादन की बात 3800 रुपया प्रति कट्टा के दर से 1,08,400 रुपया विक्रय प्रतिफल के बाद स्वीकार किया गया। साथ ही मृतक प्रतिवादी को एवं उनके लड़कों द्वारा यह भी स्वीकार किया गया कि प्रतिवादी द्वारा वादी से एकरारनामा के निष्पादन के समय 20,000 रुपया अग्रिम के तौर पर 28/98 को दिया गया। एग्जिबिट 1/1 एकरारनामा पर प्रतिवादी धनंजय हजरा का दिनांक 8/9/98 का 505 रुपया लेने का पावती। उभय पक्षों द्वारा इस बात पर स्वीकार नहीं किया गया कि विवादित जमीन के संबंध में बिक्री हेतु एकरारनामा का निष्पादन वादी एवं मृतक प्रतिवादी के बीच नहीं है। यह सत्य है कि एग्जिबिट 1 पर साक्षियों का हस्ताक्षर पदस्थ 1 की तिथि से भिन्नता है, लेकिन पदस्थ 1 के अस्तित्व को स्वयं प्रतिवादी धनंजय हजरा एवं उनके लड़कों द्वारा स्वीकार किया गया। सिर्फ पदस्थ 1 की शर्तों का आधार पर वादी पर मृत प्रतिवादी धनंजय हजरा द्वारा अपने अपने भाग के संविदा के विनिर्दिष्ट अनुपालन के बिंदु पर विरोधाभास है। दोनों पक्ष द्वारा यह कहा गया कि ये लोग अपने अपने भाग का अनुपालन करने के लिए तैयार थे, जबकि दूसरा पक्ष तैयार नहीं था। पदस्थ 6 के अवलोकन से स्पष्ट होता है तथाकथित जमीन को वादी के पक्ष में बिक्री हेतु अनुमति प्रतिवादी धनंजय हजरा को 28/6/2024 को बाद में लंबित रहने के दौरान मिली। इसके पूर्व वर्तमान वादी द्वारा दाखिल किया जा चुका था, लेकिन आदेश मिलने के बावजूद भी मृतक प्रतिवादी धनंजय हजरा द्वारा संविदा का विनिर्दिष्ट अनुपालन नहीं किया गया एवं विवादित जमीन में से 28.07 जिसमें प्रतिवादी संख्या 2 अक्षय कुमार सिंह को पदस्थ 7 तथा अथवा ए द्वारा बाद को लंबित रहने के दौरान बिक्री कर दिया, जिसके आधार पर प्रतिवादी अक्षय कुमार सिंह दाखिल खारिज कराकर एग्जिबिट सी से C/1 सरकार के मालगुजारी रसीद दिया जा रहा है। यह सत्य है कि एकरारनामा का निष्पादन 1998 में किया गया था, लेकिन प्रतिवादी को जमीन बिक्री का आदेश उनके आवेदन पर अपर समाहर्ता दिनांक 6/7/2004 द्वारा दिया गया। पदस्थ 2, 3 और 4 अवलोकन से स्पष्ट होता है कि दिनांक 29/5/2002 को वादी द्वारा वकालतन नोटिस देकर मृतक प्रतिवादी धनंजय हजरा को 1998 के तथाकथित एकरारनामा का अनुपालन करने हेतु कहा गया, जिसका अनुपालन मृतक प्रतिवादी धनंजय हजरा द्वारा नहीं किया गया। इस बाद में मृतक प्रतिवादी धनंजय हजरा द्वारा अपना लिखित बयान में 23/7/2004 को एवं अतिरिक्त लिखित बयान 24/11/2005 को दाखिल किया गया। यह जानते हुए कि विवादित जमीन के संबंध में न्याय
Appellate court क्या थी?
Now, appellate court you will also may kindly see para 11 page 8 is the points for consideration. Para 11 page 8.
Yes.
Yes, ma'am. Point number 1, whether the plaintiff respondent was ready and willing to get the sale deed executed in favor of the on payment of consideration money, balance consideration money. Point number 2, has Akshay Kumar Singh acquired right title interest? These are the two issues. Now, so far the validity of the agreement and time is the essence of contract. That is not the issue before both the courts. Now, point number 1 and 2 have been dealt by the learned appellate court in para 12 onwards. You will also may kindly see page 15, para 15, page 13 of the appellate court judgment.
Yes.
Para 15. After going through above discussed evidence on record, I find the plaintiff respondent has entered into agreement with Dhananjay Hajra to purchase 47 tisweel of land and plot number such and such on 24/5/98. He has purchased the stamp paper, and when the sale deed was not executed by Dhananjay Hajra, he has returned the same. The permission was granted by the then concerned Dhananjay Hajra to sell the property in favor of Jayaprakash Chaurasia. As per settled principle of law, where any person made a contract to transfer for consideration of any moved property by writing signed by him or on his behalf, from which the terms are necessary to constitute the transfer can be ascertained with the reasonable certainty, and the transferee has in part performance of the contract taken possession of the property or any part thereof, being already in possession, continuous in possession, in part performance of the contract has done some act or furtherance of the contract, then it can be said that he is willing to perform. So it is a presumption. It is not the compliance of section 16(1)(c). I rely upon the two Supreme Court judges.
Substantial question of law बताइए.
No, my lord, your lordship may kindly see
Substantial question of law
Yes.
बताइए.
point number A. Your lordship will get the note at page. Yes, ma'am. Page number 7. Small a, and then we wrote small c.
Or the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the point regarding readiness and willingness to perform the part of the contract by the plaintiff in the specific performance of contract as contemplated under section 16 within bracket 1 within bracket C of the Specific Relief Act has not been considered properly by both the courts. He submits that the learned trial court has put the onus on the defendant without recording that the plaintiff was ready and willing to do his part of the contract. And so far as the learned appellate court is concerned, the appellate court has observed that the plaintiff was put in possession of the property by what and has entered into the provisions of section 53 capital A of Transfer of Property Act instead of examining the case within the contours of the readiness and willingness under section 16 in bracket C 1C of the
Specific
Relief Act
1963.
1963. The learned counsel has also submitted that the agreement in the present case is of the year 1998 and during the pendency of the suit, नहीं,
Yes.
सूट के पेंडेंसी में ट्रांसफर हुआ है.
जी,
During the pendency of the suit, the property was transferred,
portion part of the property.
a portion of the property was transferred in favor of the defendant number 2 by the defendant number 1
30th January 2006.
on 30th January 2006, but neither any relief was sought challenging the sale deed, nor any relief was sought asking the subsequent purchaser to join in the execution of the sale deed.
Yes.
He has referred to substantial question
A.
under the aforesaid circumstances, and upon going through the judgments passed by both the courts, this court is of the view that this appeal is admitted for hearing on following substantial question of law.
A, C and E. E is the onus.
इतना सारा substantial question of law.
Onus दिखाई दी मुझे submission में, तो सीधे हम E.
A लिखिएगा. Whether the learned courts have properly exercised their power while considering the readiness and willingness to perform the part of the contract by the plaintiff in terms of section 16(1)(c) of specific relief act. इतना में सब हो गया, ओनस ओनस सब कवर हो जाएगा उससे, सारा सब कवर हो जाएगा.
C था वो जो पार्ट.
हाँ, yes. C में लिखिएगा, whether the suit for specific performance of the entire area of 47 decimal could be passed in favor of the plaintiff in absence of any relief regarding cancellation of the subsequent sale deed with respect to half portion of the property, with respect to a portion of the property, and without claiming any relief in connection with asking the defendant number 2 to join the defendant number 1 for the purposes of execution of sale deed in favor of the plaintiff by virtue of specific performance of contract. यही दोनों है. एक लाइन आपका छूटा हुआ है, वो हम डाल दिए. ज्वाइन करने के लिए होता है प्रेयर. नहीं यार, आपके दिमाग में कैसे नहीं था? ऐसा नहीं हम बोल रहे. आजकल कर रहे हैं स्पेसिफिक परफॉर्मेंस का बहुत सारा मैटर्स, तो ये सारा चीज आ रहा है धीरे धीरे.
फ्यूचर के लिए हमारे दिमाग में आएगा.
लेकिन इस पर लॉ ऑलरेडी काफी कुछ सेटल हुआ है, लेकिन फिर भी इसको एक बार डिसाइड करने की जरूरत है. कोर्ट्स को बहुत कंफ्यूजन है, हमारे ट्रायल कोर्ट्स वगैरह को काफी कंफ्यूजन है इसको लेकर, क्योंकि जैसा देख रहे हैं. लेट नोटिस बी इशूड टू द
respondents. They are all of the district of Dhanbad.
Respond to the respondents for which requisite under ordinary process be filed by the appellant within a period of 1 week from today.
Respondent number, respondent number 1 only, because others are the pro forma who were the defendant in the court.
सबको जाएगा. सबको जाएगा.
ठीक, 3 आदमी जाएगा.
हाँ, इसको भी जाएगा. Let the records be called for from the concerned court. Considering post this case under the heading for final disposal on, बताइए कब करेंगे?
जब एक महीना 1.5 महीना के बाद कोई भी.
एक बार हम इसको रख रहे हैं 28 मार्च को, 27 मार्च को. ठीक है, 27 मार्च अंडर एप्रोप्रिएट हेडिंग. उस दिन अगर कोई अपियर कर जाएंगे तो हम लोग उसको एक और डेट दे, एक डेट देने के बाद फिर बस कर देंगे. इस बीच मेरा 2-4 तो आ जाएगा स्पेसिफिक परफॉर्मेंस वाला जजमेंट, देख लेंगे. आई एम इन द प्रोसेस ऑफ प्रोनाउंसिंग सर्टेन जजमेंट, सुप्रीम कोर्ट का जजमेंट फाइनल डिस्पोजल
Okay.
स्पेसिफिक परफॉर्मेंस कितना देंगे?
Item 19, second appeal 263 of 2019.
This appeal is concurrent pending on two issues now.
You are for the
I plan to ask
You are for the appellant, for the plaintiff or defendant?
plenty.
Plaintiff. What was the suit for?
Suit for declaration that sale deed number 9356 dated 18/10/2002 in respect of Figure land purported to have been executed by Shravan Tiwari, who was father of plaintiff. In favor of Shanti Devi, defendant number 1, he required ab initio as the property is proportionary property of the plaintiff as well as without payment of consideration.
What is the finding of the trial court? It was a joint family property.
No, finding given that the family is joint,
But the property is self-acquired.
but without any evidence,
किसके नाम से है property?
father के नाम से. Case of the plaintiff is that
Self-acquired किसका declare किया?
vendor का,
Father का ना?
father का.
तो जिसके नाम से है उसके नाम से.
But
Merely because the family is joint, that does not mean that an individual person cannot buy property in his own name from his own source of income.
family joint lot, that is a
अरे भाई joint family में हर एक आदमी जो property खरीदेगा वो joint family property थोड़ी हो जाएगा.
but by the sources of income for purchasing
Father was
the
unemployed.
self property.
Father was unemployed.
No, not employed. Which the defendant taken plea that the father of the plaintiff was using to sell the milk now.
So
So from selling the milk, he has earned money and he purchased the property. But there is no
दूध बेचने वाला आदमी प्रॉपर्टी नहीं खरीद सकता है. लीगल बात है.
नहीं. Whether that business, milk selling business, was self business or joint family business.
आपका प्ली था कि मिल्क सेलिंग बिजनेस वाज अ जॉइंट फैमिली
No.
बिजनेस.
Whereas I think there was a joint family business from on the basis of the ancestral property, the plaintiff with all partners and enhanced the joint family business and from that joint family business property was purchased and therefore property was purchased in the name of father and mother. So that property is a proportionary property, so not the plaintiff has no right to sell the property without consent of the other proportionary members.
Plaintiff was not the vendor. Plaintiff was seeking declaration that this sale deed is bad.
Ab initio, that
The defendant was the seller.
no, the defendant, sir. Father of the plaintiff, defendant is purchaser. Defendant number 1 is purchaser and defendant number 2 is her husband with help of defendant number 2. Defendant number 2 is an advocate, they are a very good relation with the family and taking that at disadvantage. Defendant 2 got
देखिए एडवोकेट होकर ना एडवोकेट का नाम लेके बहस मत करिए, अच्छी बात नहीं. एडवोकेट है इसलिए बहुत चालू पुर्जा होगा ऐसा तो नहीं है कोई लोग.
not necessarily.
इसीलिए एडवोकेट का नाम मत लीजिए. Please
Not
don't do that.
necessarily, but that finding is not the family is joint and the court, especially lower appellate court, on the basis of one decision reported, in Supreme Court's judgment law, volume 4 JBCJ page 298 law. In this case, Lord, the Supreme Court held that if the father
JBCJ page number
page number 298,
298,
298,
Supreme Court.
Supreme Court.
दीजिए judgment.
Kindly see para 17, in which what was the factual matrix of that case law. In that case,
Father करता थे
uh,
इस केस में father करता थे.
no, case of the plaintiff is that when the father was at the age of 60 years, he became physically and mentally unfit, my lord. And his Kartaship was handed over to first son, plaintiff number 1, my lord. So even the father was not mentally.
देखिए सेकेंड अपील में इतना कहानी नहीं, कॉन्करेंट फाइंडिंग है ना, इतना नहीं कहानी सुनेंगे आप. हमको बताइए क्या सब्सटैंशियल क्वेश्चन है.
सर क्वेश्चन लॉ है कि वेदर इसमें जो इस सुप्रीम कोर्ट का रूलिंग पर जो रिलाई किया है लोअर अपील कोर्ट और ट्रायल कोर्ट दोनों, rather this ruling is in my favor because in that case in sale deed itself the legal necessity was referred. What was the legal necessity? In that case, there is no such in that sale deed lot. There is no such averment.
Need not be, that is his own property, he is selling it. लीगल नेसेसिटी को लिखने का क्या जरूरत है? If there is a self-acquired property of a person, he can sell it without any need.
So, what is the evidence of self-acquired property?
You want to say there is no evidence that it was a self-acquired property.
There is no evidence that it is a self-acquired property. Simply say that selling milk was the self business of the seller.
काफी है.
But must have evidence that income was sufficient to purchase the
Need
property.
not be. Need not be.
But the finding of the lower appellate court is that the property was a joint, the vendor was a member of joint family, but he has sold the property for legal necessity of the family. But if it is that legal necessity in comparison of this ruling lot, there must have averments in the sale deed itself, and onus lies upon the purchaser to prove that there was such a legal necessity by producing evidence. In this case,
Seller was defendant number.
no, seller had not been the party. Seller was father of the plaintiff.
He expired.
No, he is alive.
But still he was not made party.
The case of the plaintiff was not sound mind, not
Who was not sound?
gender.
Father of the.
Father of the plaintiff.
क्या proof है? Not sound mind.
Not sound mind, not mentally upset, not
Mentally upset होने से क्या sale deed नहीं execute कर सकते हैं? कोई डॉक्यूमेंट है, कोई मेडिकल एविडेंस है?
मेडिकल एविडेंस दिया गया है, लेकिन डिसबिलीव किया है कोर्ट की, इसको डॉक्टर का एग्जामिनेशन नहीं किया है, इसीलिए डिसबिलीव किया उसको. तो इवन इफ but there must have evidence that property was purchased from self acquisition.
पैरा 14 पढ़िए एपेलेट कोर्ट का, पहले ट्रायल कोर्ट का फाइंडिंग पढ़िए फिर उसका पढ़िए. इतना नहीं पॉसिबल है. पैरा 14 पढ़िए एपेलेट कोर्ट का जजमेंट.
Para 15 of a trial court.
एपेलेट कोर्ट.
The main question before the learned lower court was whether schedule A and B was reviewed was the self-acquired property of plaintiff by sale deed number 77 both the date dated 8/12/1982. The same have not been filed before the learned lower court for its perusal to come to a conclusion as per pleadings of the plaintiff. The plaintiff
The same have not been filed means?
But this sale deed is not in question.
But it was not filed.
That you are not.
Not exhibited.
Not exhibited. The said in question is Exhibit B. The plaintiff
And you are the plaintiff. You wanted this particular, just a moment, your relief was that this is your self-acquired property.
no, this is the compulsory property.
Just a moment. You wanted this sale deed to be set aside of the year 2002, correct?
Yes.
Okay, executed by father of the plaintiff in favor of defendant number 1.
Yes.
By saying that it is a co-pastory property.
The second ground is that without consideration, without payment of consideration.
No, we'll see that. But the property was purchased by the plaintiff, by the
In the name of father. Property was this property was purchased by plaintiff
Benami
in the
tha.
name of father.
Benami.
And
Benami.
yes. And father sold that property to defendant number 1.
So these two deeds by which in the year 1982, by which the plaintiff had purchased the property, that was not exhibited.
That I know. This is an admitted case that
कुछ तो उसमें गड़बड़ होगा ना, इसीलिए एग्जिबिट नहीं की.
नहीं admitted है कि इनके फादर के नाम से है.
सिर्फ नाम से नहीं ना, आप तो बोल रहे सेल डीड में रिसाइटल नहीं है. तो कहानी सुना रहे हैं कि सेल डीड में नहीं लिखा.
इस सेल डीड में नहीं. जिस सेल डीड से डिफेंडेंट नंबर 1 को जो बेचा गया है उसमें रिसाइटल नहीं है.
उसमें रिसाइटल नहीं है, लेकिन जिस सेल डीड से परचेज किया गया है रिसाइटल तो उसमें ना होगा. ये मेरा सेल्फ एक्वायर्ड प्रॉपर्टी है कि नहीं है.
उसमें जो उनके नाम से है, बेचे हैं जो
अरे भाई, खरीदते समय ना बताएंगे कि पैसा कहाँ से आया मेरे पास. खरीदने के लिए, बेचने के लिए किसको पैसा चाहिए.
अच्छा ठीक है, उसमें नहीं फाइल करते बिकॉज दैट नॉट डिस्प्यूटेड डीड. दैट सेड इन क्वेश्चन इज एग्जिबिट बी. दैट कॉपी इज आई हैव गॉट नॉट.
आपके उससे नहीं चलेगा.
इसको
जब
बात
एग्जिबिट
करते
नहीं
हैं.
कराया है तो नहीं देख सकते.
ट्रायल कोर्ट हैज taken note of this exhibit B. In this deed, the vendor has written that जो हक हुकूक मुझे और मेरे लड़के को प्राप्त है और सबके कंसेंट से हम लिख रहे हैं, तो वो हक और हुकूक जो है अपने लड़के को एक्सेप्ट किया है सेल डीड में.
आगे पढ़िए ना, इसको फाइंडिंग पढ़िए. पैरा 15 पढ़िए.
Paragraph 15. Plaintiff have, first consideration that this document has not been considered by your appellate court. Trial court has considered.
चार पढ़िए ना, पैरा 15.
The plaintiff have claimed that sale deed number 9356 dated 10/18/22 be declared void ab initio on the ground that vendor Shravan Tiwari was not physically and mentally fit to execute the same, and his LTI has been obtained on the said sale deed without consideration. The same has not been filed by the plaintiffs to substantiate the claim or reason based known to them. The medical prescription issued by Dr. U.N. Chobe dated 10/8/2022 and Dr. Tushar Kwanti Ganguly dated 15/8/2002 have been filed by the learned counsel of the plaintiff, which have been marked Exhibit A 1 and 1A respectively. As per Exhibit 1 and 1A, it is not clear that the vendor patient Shravan Tiwari was not mentally and physically fit to execute the sale deed number such and such, nor the aforesaid medical officer have been produced before the learned lower court to come to the same conclusion. As such, it has been rightly argued by the learned lower court that vendor Shravan Tiwari was mentally and physically fit to execute the sale deed number such and such in favor of defendant number 1. The vendor Shravan Tiwari has neither been made a party nor has been examined on behalf of the plaintiff to this effect. The certified copy of the complaint case number such and such इतना SLD नंबर इतना सबकी पोजीशन इतना डिवीजन Shravan Tiwari इसलिए केस नंबर इतना नोटिस इशूड इतना डिवीजन नंबर 66/2005 notice issued by the railway judicial magistrate in RP case number such and such, and this one sale deed number इतना marked Exhibit E B1, B2, B2, B2 before respectively have been filed by learned counsel evidence for the defendants, denying the assertion of plaintiff with regard to mental and physical fitness at the relevant time while executing the sale deed number 935C dated 18/10/2002. It has been cleared by the plaintiff before the learned lower court that no consideration amount was ever paid to the vendor Shravan Tiwari. This fact has been denied in WS by the learned court counsel for the defendant, and material witness have been produced on their behalf before the learned lower court to substantiate that consideration amount was paid to the vendor Shravan Tiwari in presence of the witness. The money received of the consideration amount dated 26/10/22 has been filed by learned counsel for the defendant respondent marked Exhibit A. Now, this Exhibit A is contrary to the pleadings of the party. The defendant number 1 is the purchaser and defendant number 2 is her husband.
आप प्लेंटिफ हैं, ये श्रवण तिवारी को पार्टी क्यों नहीं बनाए? ही इज अ वेंडर.
It is an unsound mind.
अनसाउंड माइंड तो क्या?
According to plaintiff, unsound mind, although not disbelieved by the
You have not even, if a person is an unsound mind, then he will be represented through a guardian, or he will remain unrepresented. You are challenging the sale deed executed by him, and he is alive. You don't make him party.
According to plaintiff,
हाँ.
he is
बेचने वाले को पार्टी क्यों नहीं बनाए?
He is not sound mind, Lord. तो plaintiff the being son is the guardian.
अच्छा.
और उसका गार्जियन
गार्जियन अपॉइंटमेंट होता है. गार्जियन का अपॉइंटमेंट होता है प्रॉपर. And if there is a conflict of interest between son and father, then under such circumstances, son will become the guardian of father. Conflict of interest है ही, because he is a person who has sold the property.
But then, my lord, if he is not sound, unsound, my lord, then defendant have also मतलब onus to bring as a witness.
समझ गए. अब बताइए कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ की कहानी सुनिए.
मतलब first, my lord, the trial court has referred Exhibit B, my lord, where that is said in the question, my lord, and recital itself shows that the para 8 of the sale deed, my lord, shows that property in question is not saleable, but rather it is a personal property, joint property. Para 7 has not been, देखिए इसमें कंसेंट लिया गया तो लिखा गया ट्रायल कोर्ट से, लेकिन इसमें लिखा है कि जो हमको या हमारे लड़का का जो हक हुकूक प्राप्त है वो सभी हक हुकूक परचेजर को प्राप्त होगा. तो ये हक हुकूक जब लड़का को प्राप्त ही एक्सेप्ट करता है वेंडर, तो फिर क्या बाकी रह जाता है कि इसको कहना कि सेल्फ एक्वायर्ड प्रॉपर्टी रहता तो कंसेंट ना कंसेंट का जरूरत था, ना ये लिखने का जरूरत था कि उसको हक हुकूक प्राप्त है. तो दिस एस्पेक्ट हैज नॉट बीन कंसीडर्ड बाय द बोथ द कोर्ट.
दोनों चीज आपने नहीं प्रोड्यूस किया. पिताजी के नाम से जो सेल डीड था वो नहीं प्रोड्यूस किया, और पिताजी को पार्टी भी नहीं दी. और पिताजी ने जो लिखा है, आप बोलते हैं अनसाउंड माइंड, तो जो लिखा है वो साउंड माइंड से लिखा है कि अनसाउंड माइंड से लिखा है? दोनों चीज चलेगा कि पिताजी अनसाउंड माइंड थे लेकिन उन्होंने सेल डीड में लिखा है कि जो हक हुकूक है वो हम दे रहे हैं. दोनों चीज साइमल्टेनियसली चलेगा? दोनों चीज साइमल्टेनियसली चलेगा क्या? On the one hand, you say that he was of unsound mind, and therefore whatever has been written in the sale deed was written, and you are relying upon that statement made by a person of unsound mind. दोनों चलेगा?
दोनों नहीं चलेगा, लेकिन सेल डीड इन फेवर ऑफ द डिफेंडेंट इनके फेवर में है, तो उसी डॉक्यूमेंट में जब लिखा हुआ है कि ये हमारे लड़के का भी हक हुकूक इसमें है और हम कंसेंट ले लिए हैं, तो
पागल आदमी का कंसेंट ले लेगा तो क्या होगा?
उनका एडमिटेड हो फैक्ट है कि उसको ये
जो पर्सन ऑफ व्हेन अ पर्सन इज ऑफ अनसाउंड माइंड, उसका एडमिशन डिनायल ये सब का क्या रेलेवेंस है?
डिफेंडेंट टेकिंग प्ले दैट इज नॉट अनसाउंड माइंड. देयरफॉर डिफेंडेंट का जो केस है कि इससे जो है हमको राइट टाइटल हुआ, तो डिफेंडेंट का ही जो सेल डीड है उसी से जो है ये होता है कि ये अनसाउंड माइंड नहीं भी थे, तो इनका लिखता है कि ये ज्वाइंट प्रॉपर्टी है, हमारे लड़का का भी इसमें हक हुकूक है जो कि परचेजर को प्राप्त होगा. हम तो इसको कहते हैं कि ये वाइट डॉक्यूमेंट है, लेकिन इसको पर रिलाई कर रहे हैं डिफेंडेंट. तो इस दूसरी बात यह है, so far concerning payment of consideration money, the sale deed itself averred that no single pie was paid at the time of registration of the document. That has not been taken into consideration by both the court below. And Exhibit A has been relied upon, that is contrary to the pleadings of the defendant. कहता है डिफेंडेंट कहता है, डिफेंडेंट 2 है जो प्लेंटिफ, डिफेंडेंट नंबर 1 कहते हैं कि डिफेंडेंट नंबर 2 के सामने में पेमेंट हुआ एग्जिबिट थ्रू एग्जिबिट ए, और डिफेंडेंट नंबर 2 कहते हैं कि हमको तो इस ट्रांजैक्शन के बारे में जब कोर्ट से सम्मन प्राप्त हुआ है उसके बाद जो है सो हमको इसके बारे में हम उसके पहले कुछ नहीं जानते थे। तो कंट्रारी टू प्लीडिंग्स जो डॉक्यूमेंट्स है उसको कंपेयर नहीं किया गया और उसको जब सिंपली जो है सो दिखा गया एग्जीबिटेड जो है सो शो करता है कि पेमेंट हुआ, बट whether the valid document, whether it is contrary to the pleadings or not, that has not been considered. The trial court has my lord, at para 14 of the judgment had taken into consideration of this exhibit B, my lord. para 14 पढ़ देता है कि उनका केस क्या है, उनका WS में से। Further pleadings of the above defendant is that it is true that defendant to Madan Tiwari, who is an advocate at Daltonganj, but residential village Reward is at distance of 8 km from village Baralota, so it is incorrect that defendant were to taking benefits of with the condition of Shravan Tiwari without payment of consideration money got prepared a sale deed by Dukharan Tiwari village Baralota and obtained LTI about the same without expelling the facts of the sale deed to the father of the plaintiff in the name of his wife. It is also incorrect that defendant number 2 succeeded in obtaining Chirkut from the father of the plaintiff. As a matter of fact, defendant number 2 was neither present nor he had taken any part in execution and payment of consideration of the sale deed. सेल डीड में कंसीडर में इनका कोई हाथ नहीं बोलता है, जबकि ये एग्जिबिट ए जो है उसमें एलटीआई को अटेस्ट किए हैं। दैट्स एग्जिबिट ए शोज दैट डिफेंडेंट नंबर 2 इज अटेस्टेशन ऑफ एलटीआई ऑफ द वेंडर दैट इज contrary to his defense taken in WS. This aspect has not been taken into consideration by both the court. So on the payment of consideration money also, the finding is without any valid evidence. And the ruling of the Honorable Supreme Court is not compared with the factual matrix of the present case and that case law. In that case, the sale deed itself about the legal necessity was for payment of loan, for advancement of agricultural land, कि कौन लोन लिया था उसको ला करके उससे गवाही कराया गया है। The onus has been discharged by the defendant by bringing on the report कि किसको लोन दिया गया था, किसको पेमेंट किया गया, इसमें कुछ नहीं है। So both issue number 5 is whether suit property is joint property, proportionate property or self-acquired property, and issue number 6 and 7 is whether the consideration money was paid or not. On both issue, the finding recorded by lower court and lower appellate court is without evidence contrary to the findings conducted to the defense taken in the WS, and therefore it is perverse and illegal. sale deed itself shows that no consideration money was paid at the time of execution and registration of the sale deed.
Where is
The
it
heavy
mentioned?
onus on the
Where
purchaser.
is it mentioned that the sale deed itself is showing that no consideration amount was paid? कहाँ लिखा है? सेल डीड आपका रजिस्ट्री हो जाएगा विदाउट कंसिडरेशन,
हाँ, लिखा हुआ है इसमें, देखिए
कि
देखिए,
कोई कंसिडरेशन नहीं दे रहे हैं.
लिखा हुआ है.
क्या
वही
लिखा
तो-
हुआ है?
वही तो
पढ़िए
कहा
क्या
है कि-
लिखा हुआ है? विदाउट कंसिडरेशन द सेल डीड इज बीइंग एग्जीक्यूटेड. दिखाइए कहाँ लिखा हुआ है कि बिना कंसिडरेशन का सेल डीड हम कर रहे हैं.
पेज 7 of the sale deed exhibit भी है.
पढ़िए पढ़िए.
या कि जरसमन की कुल राशि मुबलिक 1,71,000 रुपये में से एक नया पैसा नहीं पाए हैं.
आगे.
कुल राशि को मुबलिक 1,71,000 रुपये बदलें तकाजुल के समय पावेंगे. दस्तावेज वापसी रसीद के पीठ पर लेखकारी अपना हस्ताक्षर कर केवाला देने की बात लिख देना ही जरसमन की कुल राशि वसूली समझा जाएगा. So
That Chirkut, was it produced before the court exhibited?
no, not produced.
The purchaser of the property has not exhibited that Chirkut.
not exhibited. And this type of advertisements और उस पर है, इसको भी को पढ़ के सुना देखने पर पेज 8 में क्या लिखा हुआ है. या कि उपरोक्त संपत्ति पर लेखकारी या उनके वारिसान का जो भी हक हुकूक प्राप्त था वह सब आज के तारीख से लेखधारी या इनके वारिसान को प्राप्त होगा. तो हक हुकूक या कि आप अब लेखकारी
देखिए
संपत्ति.
ऐसा है, आपसे एक सवाल पूछे, अब इसका जवाब आप इंटरनल पेज 18 ऑफ द ट्रायल कोर्ट जजमेंट निकालिए.
Para 18.
पैरा 18, पैरा 36, इंटरनल पेज 18. पैरा 36. आप बोले डॉक्यूमेंट नहीं प्रोड्यूस किए ना. देखिए एग्जिबिट ए क्या है?
एग्जीबिट रिसीट है, अलग से रिसीट
तो
बनवाया
क्या
है.
मना ही है क्या? अलग से
रिसीट नहीं है
receipt? जो भी है रिसीट प्रोड्यूस किए है ना कंसिडरेशन अमाउंट पेमेंट करने का.
that receipt जो बोलता है that is contrary to his defense. डिफेंस में जो लिए है, डिफेंस में जो है कहते हैं कि हमको पीडब्ल्यू डिफेंडर नंबर 2 है, कहते हैं हमको इस ट्रांजैक्शन के बारे में जब कोर्ट से सम्मन प्राप्त हुआ तब जानकारी हुआ. जबकि एग्जिबिट ए जो है उस पर जो है सो इनका जो वेंडर है उनका एनटीआई को अटेस्ट किए हुए हैं. सो दैट इज ए डिफेंस इन डब्ल्यूएस एंड इज दिस एग्जिबिट ए अटेस्टिंग द एनटीआई बोथ आर कंट्राडिक्टरी.
कैसे कॉन्ट्रडिक्टरी?
जब कहते हैं कि हमको जानकारी ही नहीं था कोई भी ट्रांजैक्शन का, कोई भी एक्सक्यूशन जो हुआ आपका उससे लेकर के पेमेंट ऑफ कंसीडरेशन मनी तक हमको कोई जानकारी नहीं था, ये कहते हैं. और वो जब रिसीट शो करता है उस पर उनका हैंडराइट, उनका जो एनटीआई है वेंडर का, उसको ये अटेस्ट किए हुए हैं. तो कंट्राडिक्टरी नहीं हुआ, ये फॉल्स डॉक्यूमेंट बना करके फाइल किया है.
एडमिट हुआ है विदाउट ऑब्जेक्शन इन एविडेंस.
लेकिन कोर्ट को तो देखना चाहिए था ना कि डिफेंस क्या है और डॉक्यूमेंट एविडेंस क्या है.
ठीक.
उसके आधार पर इसको कोर्ट को देखना चाहिए था ना. So non-consideration of payment of money has not been correctly dealt with by the court below. The evidence is against the pleadings.
If you heard the learned counsel appearing on behalf of the appellant. Appellants. The appellants are the plaintiffs in the suit. The suit was filed for declaration of sale deed number 93/56 dated 18/10/2002, executed by Shravan Tiwari, father of the plaintiff, in favor of defendant number 1, Srimati Shanti Devi, as void ab initio. And further, the plaintiffs have got right to declare it voidable. And the plaintiff have got the right to get it declared as it was voidable because the suit property was co-pastorally property. The learned counsel for the
and consideration money are not paid.
एक शब्द भी मत बोलिएगा, आपको आधा घंटा से सुनिए, जब आपका बात छूट जाए तब बोलिए. The learned counsel for the appellant has submitted that no consideration amount was paid to Shravan Tiwari, the father of the plaintiff, who had executed the sale deed dated 18/10/2002 in favor of the defendant number 1. He has also stated that the father of the plaintiff, though alive at the time of filing the suit, but he was not made party as he was a person of unsound mind. The learned counsel has further submitted that upon a query of this court, the learned counsel has further submitted that the suit property was purchased in the name of the father of the plaintiff, white sale deed number 9175 and 9176, both dated 8/12/1982, but the same was also not exhibited before the learned court. And while explaining the reason for not exhibiting the sale deed, by virtue of which the father had purchased the property, he submits that this fact that the property was purchased in the name of the father is not in dispute. He has further submitted that the suit property was co-pastorally property. The learned counsel has also submitted that as per the recital mentioned in Exhibit B, it was pleaded by the plaintiff that the alleged sale deed was not executed in sound state of mind by the father of the plaintiffs, and at the time of execution of alleged sale deed, the father of the plaintiffs was suffering from mental diseases and he was neither capable of knowing anything nor he was able to transfer the suit land. And in support of such plea, the plaintiff had also produced 2 medical papers, Exhibit 1 and 1/A, and sought a declaration that the sale deed was void ab initio. And at the same time, the learned counsel for the appellant has submitted that it was mentioned in Exhibit B itself that the father of the plaintiff was transferring the property which included the right of the plaintiffs as well. The learned counsel has submitted that in the sale deed itself it was mentioned that the consideration would be paid later on by making appropriate endorsement in the parcha, but there was no evidence in connection with any endorsement made in the parcha showing payment of consideration amount, and accordingly he submits that on account of the aforesaid reasons, firstly that the property was co-pastory property, and secondly no consideration was paid in connection with the property, the sale deed executed by the father of the plaintiff in favor of the defendant number 1 was void ab initio, null and void. He submits that both the courts have failed to appreciate these aspects of the matter, and accordingly substantial question of law be framed and this appeal be admitted for final hearing. He has relied upon the judgment passed by Honorable Supreme Court reported in 2018 within bracket 4 bracket closed ABCJ 298 SC paragraph 7 to paragraph 17 to submit that in the said case the High Court had allowed the appeal by the defendants and dismissed the suit, and it was held that the suit land was an ancestral property of the family, and Pritam Singh, being a karta, had a right to sell the suit land, and that there was a legal necessity of the family for which the suit land was being sold by karta. And such facts having been duly mentioned in the sale deed itself, the sale was held to be bona fide, legal, and for valuable consideration. He submits that there is no mention about the legal necessity in the sale deed executed by the father of the plaintiff in favor of the defendant, and therefore the co-pastory property was sold without there being any legal necessity, and consequently the sale deed was void ab initio. कुछ और बचा है आपका? कोई पॉइंट छोड़े हैं आपका? सब हो गया ना कंप्लीट? बस ठीक. The arguments of the appellant is concluded on the point of framing substantial question of law. एक दिन ऑर्डर्स में लिख के हम ऑर्डर करेंगे इसको. Post on 11th for orders. 11 तारीख तो ये तो सब्सटेंशियल क्वेश्चन ऑफ लॉ पर है ना. ऑर्डर तो अगर फ्रेम करना होगा तो कर देंगे और डिसमिस करना होगा तो डिटेल ऑर्डर पास करेंगे. इतना लंबा क्या ही लिखेंगे.
From subcommittee list for orders item 3, first appeal 88 of 2017.
4 बज गया ना, अभी ऑर्डर्स का टाइम है. कहाँ है मिस्टर मुकुल कुमार? आप हैं इसमें रिस्पोंडेंट? आप हैं इसमें? बताइए, चेक करिए, द आइटम नंबर बताइए।
Item number 3, first of 88 of 2017 from supplementary list.
नहीं, चेक क्या करना है इसमें? आपका नाम है तो है, नहीं है तो नहीं है। नहीं है ना आपका नाम, कोई बात नहीं। बाकी रिस्पोंडेंट एब्सेंट की क्या करना है?
Next substitution का ये होगा.
Item number 6.
देखिए आइए नंबर 1541 of 2022 in first appeal number 88 of 2017. The learned counsel for the appellant is present. Nobody appears on behalf of the respondents. The learned counsel submits that this petition has been filed for substitution of appellant number 1 who expired during the pendency of this case on 6/5/2021, leaving behind his two sons, namely
Chotte Bedia.
Chotte Bedia
Ishwar.
and Ishwar Bedia, whose details have been mentioned in paragraph 3 of the interlocutory application. He submits that the wakalatnama of the aforesaid two persons have been, of the proposed legal successors has been annexed along with the interlocutory application. This petition was filed. This petition was filed way back in 2022. इसका कोई counter आया है? But no counter affidavit as such has been filed. In such circumstances, the cause of action still counter तो आया है?
FM not against the further delay.
Cause of action still survives. Accordingly, IA number 1541 of 2022 is hereby allowed only for the purposes of the present first appeal, and counsel for the appellant is directed to delete the name of the appellant number 1 from the cause title and insert the name of the legal heirs and successors in red ink during the course of the appeal. दूसरा limitation बताइए.
Limitation is there for 1482 1354 days.
IA number 1482 of 2022. In FA number 88 of 2017, the learned counsel for the appellant submits that this petition has been filed for condonation of delay of 1354 days in filing this appeal. He has further submitted that with respect to land in the vicinity, different amount of compensation has been paid, and the appellants are poor persons and they could somehow collect money to approach this court he has also submitted that the appellants are rustic travel and have very limited income and information. No counter affidavit as such has been filed to the interlocutory application seeking condonation of delay. Considering the fact that being satisfied with the cause shown in the interlocutory application, seeking condonation of delay, the delay in filing the first appeal is hereby condoned. IA is allowed. Admit. और कोई बच्चा है? Defect.
कोई डिफेक्ट
नहीं बच्चा है ना?
मे बी फिक्स्ड ऑन 25th of March में
किसके साथ?
ये 2017 batches cases are of Modi village.
17 first of
82 of 17.
24
Office is directed to place this case on 25th of March 24th of March 2025 and along with first appeal number 82 of 2017 and other analogous cases at the request of the counsel for the appellant who has submitted that similar matters are coming up on the same date. Let this order be communicated to
And
us.
submit one thing, because in this case also, there is also party, necessary party. Now, advocates previously, whoever allotted money, they are not appearing.
आपको जो मन करे लिखिए तो किसी को नोटिस करना है.
This is, we have filed counter in the main application. Railway is necessary party, that's why I am not submitting counter if possible. Maybe positive process is good.
यूनियन ऑफ इंडिया को तो सर्व किए होंगे ना? रेलवेज को सर्व किए हैं आप?
हाँ sir, and as per the direction given on that very day, all the copy with the restoration and limitation, so we are assimilating that, we will serve it to the railway.
Till date was it was not solved.
अभी स्टिल बाकी है टाइम है, we will serve it.
डिले कंडोन होने के बाद क्या सर्व करें?
As per that very day, it has been directed to us.
कौन वेरी डे? हमारा जो ऑर्डर होता है ना राइटिंग में होता है. कौन सा ऑर्डर से डायरेक्शन?
Last order.
Not this case.
सॉरी?
On different appeals.
Not in this case, but I will supply it. I undertake to supply all the documents after.
डिले कंडोन होने के बाद सप्लाई करके क्या फायदा है?
Yes, this is the thing.
ऑलरेडी तो कॉपी दिया हुआ था, तभी तो आया था.
वही तो हम जानना चाहते हैं कब कॉपी दिए हैं. उनका नाम भी नहीं अपीयर कर रहा. उनका नाम तो नहीं अपीयर कर रहा.
Previously, Pratish Kumar.
Previously means what?
When this file was with Mr. Advocate Pratish Kumar.
कहाँ दिख रहा है इसमें? तो कोई रिसीविंग नहीं है. नाम भी नहीं है. नाम है मिस्टर प्रतीश कुमार है?
No, he is not in final.
We don't bother about it. आप लोग का पैनल का क्या कहानी है? आप लोग का पैनल का कहानी आप लोग अपने तक रखें.
But by law,
I
We do not know. कॉपी सर्व पे बात करता मैं उनका नाम अपील कर रहा है.
he will not able to
We do
access.
not know. अभी आपसे 3 बार पूछे थे आप हैं इसमें. आप सीधा डिनाई कर दिए कि हम नहीं हैं इसमें. आप यूनियन ऑफ इंडिया के काउंसिल हैं.
Yes.
तो व्हाट लोकस डू यू हैव टू से आफ्टर द ऑर्डर ऑफ आफ्टर द प्रोनाउंसमेंट ऑफ ऑर्डर? आपसे 3 बार पूछे कि आप हैं इसमें. तो यू नेवर बॉदर्ड अबाउट इट. बस हो गया, कोई बात नहीं. अब सॉरी डिले ही कंट्रोल किए हैं आपके रहने से
Just I
दिक्कत.
have given message in this context, whatever list
कोई बात
state
नहीं.
today
कोई बात नहीं.
provided
अगला
copy. It was not provided. I have
Item
given
4.
message to each employee in this context.
Item 4, second appeal 49 of 2020.
लिख दीजिएगा उसमें the name of counsel for Union of India Mr. Pratyush Kumar is appearing in the cause list. but he has not appeared before this court. Yes?
Notice was issued to the respondent on 3/1/25. The requested magistrate manager.
क्या हुआ आपका केस में? तो लोग मर गए हैं। कौन कौन मर गए? कौन कौन मर गए हैं? Essay number 49 of 2020. Counsel for the appellant has submitted that he has not seen the records. Post this case on 10th of June. आराम से रिकॉर्ड देखते रहिए और भी 2-4 लोग मर जाएंगे। चलिए अपना आराम से टेक योर टाइम। 6 महीना बोलिए तो अगले साल रख देते हैं।
From daily list for orders item 6 first appeal 97 of 2017.
रिकॉर्ड नहीं देखे, कोर्ट देख के बताएगा रिकॉर्ड। यस अपीलेंट
Same matter. I have the same judgment. Just fixed on 24th.
इसमें आप हैं?
Yes.
काउंटर फाइल किए हैं?
ये फाइल कर रहे हैं। ये भी मिल रहा है।
कब फाइल हुआ था?
हम within 1 week.
कब फाइल हुआ था इंटरलोक्यूटरी एप्लीकेशन?
कॉपी नहीं दिया गया, कुछ कॉपी नहीं दिया गया, उसको इसी को साइन किसी में कुछ नहीं दिया गया।
कितना डिले है आपका?
More than one, same in all the matters.
Delay has
Mr.
already
Vikram
been
Kumar,
conducted.
ये so delay already
Already conducted only the substitution petition, that is I number 1540. For the same area, the same person has expired. And
अब देख लीजिए आइए का सब्स्टिट्यूशन
Yes.
में क्या बोलना है?
Substitution limitation बहुत important है।
सब्स्टिट्यूशन में किसका लिमिटेशन?
mutation has already been conducted.
6/5/21 में डेथ हुआ है। 21/2/2022 को फाइल हुआ है। इस बीच कोविड-19 का भी पीरियड है, तो इसमें डिले का कोई स्कोप दिख नहीं रहा। क्या करना है बोलिए, कर देते हैं। देखिए आइए नंबर 1540 ऑफ 2022 इन फर्स्ट अपील नंबर
97 of 2017.
97 of 2017. The learned counsel for the appellant submits that the appellant number 5, namely Dasai Vidya expired during the pendency of this case on 6/5/2021, and this petition has been filed for substitution of appellant number 5, whose details of legal heirs and successors have been mentioned in paragraph 3 of the interlocutory application. He has also referred that due to COVID-19 pandemic, appropriate steps were not taken within time. The interlocutory application was filed on 21/2/2022. No counter affidavit has been filed. However, it is not in dispute that during the period 6/5/2021 till the filing of the interlocutory application, there was COVID-19. For substantial period, there was COVID-19 pandemic. Considering the interlocutory application, the substitution of appellant number 1, appellant number 5 is hereby allowed. IA number 1540 of 22 is allowed. The counsel for the appellant is directed to delete the name of appellant number 5 in the cause title and insert the name of his legal heirs and successors mentioned in paragraph 3 of the interlocutory application in the cause title. It is made clear that this substitution has been allowed only for the purposes of the present first appeal and for no other purpose. ये इनके एक्चुअल लीगल हियर है कि नहीं है वो अलग कहानी है। इसके लिए बस इतना कर दिया। वकालतनामा फाइल किए ना साथ में,
हाँ,
इसको भी एडमिट करना है।
एडमिट करके सेम डे उसको फिक्स कर दिया।
Admit at this council for the appellant has submitted that similar matter are coming up for 24th March.
24.
Admit call for LCM. Post on 24th of March along with
It's
first appeal number 82.
82 of 17.
82 of 17. ठीक है ना?
हाँ, ठीक।
तैयारी कर रहे हैं ना?
हाँ, कर लीजिए, कर लीजिए।
क्या चार्ट वार्ट बना रहे हैं, क्या कर रहे
सब कुछ बना रहे हैं, लिस्ट आर्गुमेंट बना रहे हैं, लिस्ट ऑफ डॉक्यूमेंट्स, साइटेशंस, एवरीथिंग आर रेडी। दैट विल बी फाइन।
हैं? हर एक केस का हमको अलग अलग कहानी बताना पड़ेगा ना?
नहीं नहीं, कहानी तो बिल्कुल खाली, ओनली द अवार्ड्स आर डिफरेंट, मतलब एरिया एंड अदरवाइज एवरीथिंग इज।
आप बनाएंगे ना सारा?
हाँ, सब बना कर
हर एक केस का डिटेल देना पड़ेगा ना? अगर आपको मान लीजिए थोड़ा भी क्वांटम चेंज करना होता है तो क्वांटम यहीं पे एसेस करना पड़ता है
जी।
फर्स्ट अपील में। क्वांटम के लिए हम कुछ डिमांड नहीं कर सकते,
नहीं नहीं, आपको आपके कुछ आई विल
प्रोवाइडेड इफ देयर इज एनी एनहांसमेंट। डिसमिस हो जाएगा तब तो कोई बात
नहीं
नहीं।
नहीं, ठीक है। वी हैव आल्सो फाइल एडिशनल
आप लोग
एविडेंस,
भी तैयारी कर लीजिए।
एडिशनल
एडिशन
एविडेंस
क्या चीज का एडिशनल
कि
एविडेंस?
on other villages जो एक रेलवे ट्रैक गई है, अदर जो कंटिन्यू विलेजेस है, व्हाट द अमाउंट ऑफ कंपनसेशन।
इन लोगों का तो कहना ये है कि वो सारा कुछ कंसीडर करके ऑर्डर
Yes, ma'am. Actually,
Why
there
that-
are two village, ma'am. Two village. One village is situated in rural area and one in urban area. Now, rural area was already considered and thereafter that was enhanced. Subsequently, they are claiming award in respect of the award made in urban area.
तो
And that is that.
वो सारी चीजें अवार्ड में कंसीडर्ड
that-
है।
9 times it was enhanced, Lord.
नहीं नहीं, हम
That is already considered by the learned
I will be
court.
permitted matter to submit matter कि रूरल एरिया में ये इसी ऑनरेबल कोर्ट हैज बीन फिक्स्ड दैट 22,000 एंड नाउ वी आर डिमांडिंग इन द अर्बन एरिया 22,000 पर डेसिमल एंड हियर माय केस इज फॉर 8,000 रुपीस पर डेसिमल इन द रूरल एरिया। हाई कोर्ट से ही हो चुका 22,000 रुपए पर डेसिमल, दैट आई एम नॉट
इसी
क्लेमिंग,
पीरियड का एक्विजिशन है।
दैट आई एम नॉट क्लेमिंग, आई एम क्लेमिंग
इसी
फॉर द रूरल।
पीरियड का एक्विजिशन है।
नहीं, एक ही साथ एक ही ट्रैक के लिए एक ही साथ का एक्विजिशन है।
Every कुछ पॉकेट है उधर उसमें
आइए फाइल कर चुके हैं सब में।
हां, फाइल कर चुके हैं, एडिशनल एविडेंस भी फाइल कर चुके हैं।
सब
आप
कॉपी
सबको कुछ नहीं, कॉपी तो नहीं देंगे ये इस बार, कॉपी नहीं देंगे ना, तो हम ये सारा केस यूजुअल कोर्स में कर देंगे, अगले 20 साल में टेकअप होगा, तब तक 2-4 लोग और मर जाएंगे।
हम एवरीथिंग आई विल प्रोवाइड।
नहीं, कुछ नहीं आप प्रोवाइड करते हैं, आप ध्यान नहीं देते हैं इस बात पर। आपको रसीद यहाँ पे फाइल करना चाहिए ना। ये लोग हर बार बोलते हैं कि हमको ये कॉपी नहीं मिला, वो कॉपी नहीं मिला।
एडिशनल एविडेंस
आप
नहीं मिला
रिसीव
कोई।
करके,
इसमें हम कोडिंग में फाइल
आप रिसीव करा के उसका रसीद क्यों नहीं फाइल करते हैं यहाँ पर?
करने को अभी 2 दिन में एक नेक्स्ट वीक में कर।
ऐसा नहीं करिए ना, ये गलत बात है। उनको मौका नहीं मिलेगा फिर इस तरह से ऑर्डर देके। लिमिटेशन वगैरह तो चलिए छोटा मैटर, एडिशनल एविडेंस उनको बिना सुने हम नहीं ले सकते हैं ऐसे।
आई विल सप्लाई एंड
और यही कारण से अगला डेट में डेट होने वाला है।
नहीं सिर्फ अभी कर लेंगे, क्योंकि बार-बार डेट तो बहुत साल हो चुका है, 2017 का
कोई बात नहीं, इस बार डेट होगा तो अगला 10 साल में आएगा, क्योंकि इसको यूजुअल कोर्स में कर देंगे। आई पुट दिस केस इन यूजुअल कोर्स and it will be taken up, and age कैसे डिसाइड होगा? फ्रॉम द डेट ऑफ एडमिशन ऑफ अपील, नॉट फ्रॉम द डेट ऑफ फाइलिंग ऑफ अपील। एज ऑफ एडमिटेड केस इज टू बी डिसाइडेड फ्रॉम द डेट ऑफ एडमिशन ऑफ अपील, है ना। 4 बार डीएफडी करा के आप रेस्टोर करा लीजिएगा 2006 का सेकेंड अपील, ऐसा नहीं होता। ये सब चीज में कोई गड़बड़ी नहीं होनी चाहिए। कॉपी नहीं दिए, ये नहीं दिए, सुनने में भी नहीं अच्छा लगता कोर्ट को।
अब क्या रेडी नहीं आ रहा था, रीड कर रहे हैं।
नहीं, रसीद सबका रिसीट चाहिए, ऐसा नहीं चलेगा।
क्योंकि बिना कॉपी के तो फाइलिंग होती ही नहीं।
हम नहीं जानते हैं।
Item 7. It is the same matter.
इसमें भी सेम कहानी है,
सेम कहानी मतलब
सेम स्टोरी।
Solution
And one-
139.
इसमें
Substitution is also
सब्स्टिट्यूशन
there.
कौन सा है? सेम आदमी का है सब्स्टिट्यूशन।
नहीं ये दूसरा है, ये अपीलेंट नंबर 1 है अग्ना मुंडा। He have survived by her his wife and 5 daughters. That is IN number 1539 of 2022.
और आप लोग क्वांटिफिकेशन पे ध्यान देंगे कि इनका कितना डिले है, क्या है, ये सारी चीजें आपको हाईलाइट करना है, क्योंकि इनके डिले के कारण लायबिलिटी आपके ऊपर फासिल नहीं कर सकते हैं। हाँ, यू शुड बी वेरी वेरी केयरफुल अबाउट इट। 2-2, 3-3 साल का डिले है इनका।
It's not acceptable.
several time.
1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1
जिस केस में कंसर्न रेस्पोंडेंट का रिसीविंग हमको नहीं मिलेगा, उसमें हम एज्यूम करेंगे कि आपने कॉपी नहीं सर्व किया। अगर सर्व कर चुके हैं तो दोबारा कर दीजिए,
ठीक है,
और यहाँ पे रसीद फाइल करिए।
रसीद करेंगे, दोबारा करके रसीद फाइल
हाँ, कोई भी केस का,
ठीक है।
खास तौर पे अगर एडिशनल एविडेंस हो, लिमिटेशन हो, ये सारी चीजें जरूरी है।
For that also we require some time to take instruction lordship. At least 2 weeks before we have to give.
किसका?
Your
You
counter
are
is
saying
already
that
there.
on additional evidence he is going to file on IA.
आपका जो एडिशनल एविडेंस में ना, जिन साहब से आप लेने वाले हैं ना इंस्ट्रक्शन, उन्हीं का जजमेंट सब लगा हुआ,
No, for that he is for another area he is not saying.
उन्हीं का फाइल किया हुआ, उन्हीं का पास किया हुआ ऑर्डर होगा बाय एंड लार्ज। एरिया भले दूसरा हो, लेकिन लैंड एक्विजिशन ऑफिसर तो उस पर्टिकुलर डिस्ट्रिक्ट का एक ही होगा ना।
ठीक है, पतरातू अंचल है।
फिर
District judge court also is under challenge. District.
दूसरा डिस्ट्रिक्ट हो गया पतरातू में।
Area entirely different lordship. Area is entirely.
एरिया दूसरा डिस्ट्रिक्ट में पड़ रहा
Area
है,
is same lordship.
सेम अंचल,
But differentiated by the urban nature and the rural nature.
तो इस चीज को आपको काउंटर फाइल करने के लिए सेम लैंड एक्विजिशन ऑफिसर का ऑर्डर होगा, बाकी सब आपको कितना टाइम लगेगा?
At least
और टाइम लेने के लिए टाइम लेते रहिए
at least a
आप,
week or 2 lordship.
और दे देंगे ना जिस दिन से आप अपने से उसका
कोई
काम।
fix है lordship. ऐसे भी
नहीं,
तो
ये
अरे भाई आपको दे रहे हैं, आप अपने से रिप्लाई फाइल कर दीजिए।
one more solution मतलब जो
आप अपने से
state
reply
state of
करें।
Jharkhand is not the contesting party. Only the
DC has
railway,
also-
although he may be party, but the railway is the contesting party. and
IA
the
number
compensation has to be paid
1539
by
of
the railway.
2022. This petition has been filed for substitution of appellant number 1, namely Agnu Munda, who is said to have expired on 29/11/2020. The details of legal heirs and successors have been mentioned in paragraph 3 of the petition. The learned counsel for the appellant has submitted that there has been some delay in filing the petition for substitution, but during the intervening period there was COVID-19. Counsel for the respondents are present. No counter affidavit as such has been filed to this interlocutory application. However, it is not in dispute that during the intervening period, the intervening period was substantially covered by COVID-19 pandemic. Considering the amendments made in the interlocutory application, this IA is allowed. The appellant is directed, the counsel for the appellant is directed to delete the name of appellant number 1 from the cause title and insert the name of his legal heirs and successors, whose details have been mentioned in paragraph 3 of the interlocutory application. The wakalatnama on behalf of the legal heirs and successors has already been placed on record along with the interlocutory application. However, it is made clear that this IA has been allowed only for the purposes of the present first appeal and no more.
One more IA.
इसमें एक और IA है।
Limitation. इसमें नहीं।
एडमिट LCR और वो 24 का डेट, वो सब इसी में जाएगा। 24 तारीख का डेट ना, 24 मार्च। Admit LCR call for post on 24th of March along with first appeal number 82 of 2017. Or communicate. Okay? All ready?
Item 8, second appeal 12 of 2022.
Who is for the appellant? Yes.
The notices were issued on the last date. They have appeared now.
Who has appeared?
The respondent, the sole, they have appeared.
Sole respondent has appeared. There is only one respondent. This is second appeal 12 of 22.
There are different respondents.
Not respondent number.
वही तो हम तो चेक कर रहे हैं, हम क्या ही बोलेंगे. Counsel for the appellant submits that he has not been able to go through the office note. Post based on 1 जून में डाले हैं ना, उसी दिन डाले. 10 जून को आराम से इंस्पेक्शन करिए और अपना रिकॉर्ड पढ़िए. चलिए नेक्स्ट केस.
Item 9, CMP 893 of 2024.
Yes, appellant.
इसमें substitution was there. The वकालतनामा है, this वकालतनामा of the substituted has been filed. अब मोतीलाल देखिए.
आपका आइए है इसमें?
आइए.
क्या चीज का आइए?
For substitution and for substitution of the Surna Vidya, one of the
अपीलन नंबर? अपीलन नंबर बताइए. 16 अपीलन.
There are two appellants, Motilal Vedia and Arjun Vedia.
ठीक है, Motilal Vidya has been substituted. These are the sons of the original awardee, my lord, who has died, and we have filed them for that. And one more IAS for delay.
Delay in filing the interlocutory application.
Delay in filing the IAS, delay in filing of the CMP, my lord.
Delay in filing the CMP. यहाँ पे CMP कहाँ है? ये CMP है क्या?
हाँ, yes.
ये CMP restoration इसके first application.
आप respondent हैं इसमें?
Yes, and for the railway.
When did he expire? When did Sodhna Vidya
Sodhna Vidya
expire?
expired on 6/3/2022.
And when the case was dismissed for default?
This is for before during the COVID period.
When was it restored? Restoration का order कब हुआ है restore?
For restoration of first appeal or second has been dismissed for non-compliance CMP order on 29/11/2022 passed by Honorable Mr. Justice Anil Kumar Chaudhary, where the defect has been to be removed within preempted 2 weeks time.
29/11 को आपका DFD हुआ.
What has happened, madam?
And
893, 29/11 को नहीं हुआ है. Your Lordship.
आपको कुछ नहीं पता. छोड़ दीजिए इसको. कोई नहीं ऑर्डर करना इसमें. अच्छा है DFD पढ़ा रहे ज़्यादा ठीक है.
Serial number?
आप लोग पिटीशन नहीं पढ़ते हैं.
Serial activities there. Serial 15 in daily call list, madam.
क्या हुआ?
So dismiss हो गया. I instructed my junior I on day madam.
It dismiss हो गया restoration.
हजू इसको रेडी कल पर भी रख दिया.
नहीं कर सकते हैं.
हजू इसमें बिना सुने हो गया.
Dismiss